Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
Good morning. It is Saturday, August 19th, 2023. Thank you for joining me here on Morning Cannolis this morning. As every Saturday morning, this is our weekly review, our analysis, our discussion of those major important stories, news events in law, in government, and the aspiration for justice in America. Once again, I appreciate your spending some time with me this hour and perhaps next hour as well. 2 full hours this morning, as always, talking about justice in America, government, and law issues as well. We're coming to you live this morning from the studios of Civic Media in beautiful downtown Waukesha, but broadcasting throughout beautiful Wisconsin to stations throughout the Civic Media world, welcoming all of you to our discussion this morning. And to do that through the wonderful work, the professional work, the engaging work of my terrific producer, Anya, we're taking your phone calls at 844-967-2789 throughout these 2 hours. You can also go on the Civic Media app, find our show, and pull down your particular news station. And you can also text us comments, questions, ideas, perspectives that you wanted to share with me and with Anya this morning on our broadcast. Thank you once again for joining us. As always, we ask this morning, as we do every Saturday morning, 3 important questions. What happened? We've got some big news this past week to talk about. We'll talk about that right off the top of our show this morning. What are the facts? What do we know about what's going on out there in America and beyond? Why are those facts? Why are those news stories important? What is the significance of them? Why are they relevant? Why are they material to our understanding about who we are in America, how we live our lives, what our livelihood is all about? And what should we do? We can't always do everything about the events in our lives, but there are times, especially in these areas having to do with law and government and justice, where there are things we can do, responses we can pursue, answers we can provide. What are our actions to do, to undertake in response to those things that happen that we know are important in our lives? Asking those questions this morning, as always. Our syllabus is ambitious once again, very ambitious this morning, achievable. And it turns out that because of the great number of significant news stories in these areas throughout this past week, that this is the second in the third arc of broadcasts where we're talking about the indictments, of course, against the former President Donald Trump. We're going to begin today at the second hour to chat a little bit more about the indictment coming out of Georgia. We'll talk about that right at the top of our show, but then go back today to follow up on the discussion we began last week, analyzing, doing some exposition, actually some readings from this major indictment coming out now a couple of weeks ago with respect to the January 6th insurrection, the attempt, unsuccessful, thankfully, for America to not only undermine but to overthrow the election results of 2020. We're going to talk more in great length about that particular indictment, but we've also got some things right off the top of our show this morning, some rule of law snapshots we're going to share with you as a part of our exposition of these important stories every single week. So lots of things to talk about this morning. Again, always inviting your comments, your questions, your perspectives, and your thoughts here on Morning Cannolis. Let's begin with some of those rule of law snapshots, the 2 of them right at the top of our broadcast this morning, not having to do with the January 6th insurrection and events both before and after that, the conspiracy to overthrow the results of that election, but instead hearkening back to issues that we have chatted about before on this broadcast. That is violence in America, and in particular violence that's perpetrated by people with guns to accomplish mass shootings in America. 2 significant stories from recent weeks, from early August and then from just this past week, related to guns in America and the horrific effect of guns on our livelihood, our lives, our well-being, our safety and security, not only in Wisconsin, but throughout our United States of America. Let's begin by going across Lake Michigan to the state of Michigan, our partner right across the pond in the great Midwest, and that is the state of Michigan. A judge is scheduled to rule on September 29th, a little bit more than a month from now, on whether Ethan Crumbley should be sentenced to life imprisonment without parole. That is, of course, the harshest punishment available that's in Michigan. Ethan Crumbley, you may recall, is this Oxford High School shooter who pleaded guilty to one count of terrorism causing the death of individuals, 4 counts of first-degree murder, and 19 other charges. All of that related to what? Related to the November 2021 shooting at Oxford High School there in Michigan. You recall he fatally shot almost at completely right up against them, right at them. 4 students, injured 7 other people when he was 15 years old. Obviously, Ethan Crumbley today, older than that, but again, pled guilty to those counts of terrorism. Again, all under state law, also 4 counts of first-degree murder. Over 4 days this past week, Oakland County prosecutors, which is the circuit court, the county court in which this particular case has been prosecuted, it's a state case, it's a criminal case. They're prosecuting and trying to determine by presenting to the judge evidence of what should happen. What should happen to Ethan Crumbley for his horrific events, the horrific things that he did there in Oakland County? Prosecutors and the shooter's defense team, also part of our process, presented witness testimony over the period of the past week or so, and evidence is what's called a Miller hearing. Basically, the Supreme Court telling us you're going to imprison a minor, someone who is not an adult. You need to show some extraordinary circumstances that would justify that, keeping that prisoner, that defendant in prison for a life sentence without the possibility of parole. So that's what the question's all about. Oakland County Circuit Court Judge Kwame Rowe, R-O-W-E, will now determine again on September 29th, going to announce the decision then, whether prosecutors did in fact meet their burden to prove that a life term is a proportionate sentence for Crumbley. That coming up. Closing argument on Friday, the prosecutor, a woman named Karen McDonald, she's the Oakland County prosecutor, told the court that she had first struggled on the issue, but ultimately determined that the teen should be one of the rare minors in our nation who should receive the state's most severe punishment. That is the imprisonment without the possibility of parole, life imprisonment. She said this, she said, "I learned that there has never been an offense or offender like this one, not just in our state, but our country." She said, "This is a person who killed 4 of his classmates, solely for the pleasure of killing and to increase the body count to try to make himself famous. It wasn't impulsive, and their expert even acknowledges that." They're making reference to the defense presentation. And so that determination underway today. Prosecutors pointed out to Crumbley's premeditation of the attack as a reason he should receive this life sentence. They played audio messages in court in which the teen said, "I'm going to be the next school shooter," and that he would vow to have so much fun. Defense attorney, of course, also has a role to play in all this, asked the judge to consider some mitigating factors in favor of a prison sentence with parole eligibility at some point down the road, like his difficult home life, and ignored pleas to his parents for mental health treatment and other things. The defense counsel implored the court to give Crumbley a chance to be rehabilitated and to let a parole board at some point down the road make that determination. And so that happening in Michigan just this past week in the wake of that horrific mass shooting back in the previous year here, as we had indicated back in November of 2021. Another event happening earlier this month in August. This one also related to a mass shooting. You may recall well. Facts surrounding the shooting not at all undisputed. In the morning of October 27th, 2018, people gathering for Shabbat services. The synagogue, the Tree of Life Synagogue in Pittsburgh, Pennsylvania. And a fellow named Robert Bowers, 50, shot his way into the building, roamed the halls and the chapels, killing worshipers, considered one of the deadliest anti-Semitic attacks in the nation's history. The jury previously found Robert Bowers guilty on 63 charges, 63 separate charges, including dozens of hate crimes, civil rights offenses. Weeks later, the jury also determined that he was, in fact, eligible for the death penalty based upon this. Again, this is a federal prosecution going on in Pittsburgh, Pennsylvania. They disagreed with the contention from his lawyers, from Bowers' lawyers, that mental illness made him incapable of forming a true intent to kill, which of course is required to show that indeed a defendant is guilty of the offense conduct with which he or she is charged. They had only one decision left, and they made that decision earlier this month, whether Mr. Bowers should be executed or spend the rest of his life in prison for these horrible crimes that he engaged in. Defense and prosecutors made closing arguments in the sentencing issue earlier this month. 12 jurors began to deliberate shortly after 9 a.m. on a Tuesday morning, and shortly thereafter, the jury returned a verdict convicting Robert Bowers, again, not only as they did previously of killing these 11 worshipers, but also finding that he should indeed receive the death penalty. The death penalty imposed upon Robert Bowers, again, not a usual thing. In the federal system, it requires a huge amount of review internal, not only to the U.S. Attorney's Office in the particular district where the prosecution is being pursued, but also the Attorney General, up and down all sorts of committees and all sorts of offices inside Main Justice. Ultimately, only the Attorney General can authorize a petition, a request to the court to impose the death penalty. Here, that authorization given by our present Attorney General. And again, the jury, based upon its sequential decisions in this case, its final determination that indeed, under the circumstances of this case, Robert Bowers should be sentenced to death in the federal system. Plainly, a very controversial matter in America, the death penalty. In some states, yes, in some states, no. But in this particular case, finding the jury did that the nature of the conduct was so heinous, so extraordinarily violent and horrific that it is appropriate in the federal system to impose the death penalty upon Robert Bowers. Two events of this past month, significant in the life and the livelihood of our nation and the administration of justice when it comes to these horrific events involving guns, involving violence, and the deaths of our fellow citizens in two different venues. We know it continues. We know in America that today, to this point in this year, we've had more mass shootings than we've had days in the calendar year. When we come back, we're going to get back to some other rule of law snapshots, including some specific events this past week related to those January 6 indictments, the other indictments currently presently pending against our former president. And then we're going to go back into our discussion of the January 6th federal indictment. Stay with us for that important discussion this morning on Morning Cannolis. And we are back after that first break here in Morning Cannolis. It is Saturday, August 19th, 2023. Beginning our broadcast this morning talking about these two events in America. One in Michigan related to the shooting there, the school shooting there, and the decision coming up by a circuit court judge there about whether to impose upon the young defendant the term of life imprisonment without the possibility of parole for his killing of fellow students there, and then also chatting about this decision by the jury, imposed now by the court, to impose the death penalty on Robert Bowers for his shooting of 11 people, his injuring of many, many more at the Tree of Life synagogue in Pittsburgh, Pennsylvania. That synagogue, of course, sits in a neighborhood with a rich Jewish history. It was home to three separate congregations, all of which were gathering for services in different parts of that building in that morning. Founded in Pittsburgh more than 150 years ago, the smaller New Light congregation and the Tree of Life congregation, both a part of this conservative branch of Judaism. Third congregation, the Dor Hadash, a reconstructionist, a more liberal branch, again, indicating that this is a place of community, of open doors, and again, of a horrific place in America now because of the terror, the horrific events visited upon that congregation and upon all of us based upon what Robert Bowers did. now facing the death penalty in our federal system. I've had the benefit throughout much of this past year to have at my side my wonderful producer. We talk about her on the air quite frequently. She is terrific, and she supports me in ways big and small every single week. And Anya, I've gotten to know as also a very incredibly insightful, thoughtful person, and she has some comments to offer to all of us, me included, about this Tree of Life shooting and the result that comes this past month there in Pittsburgh. Anya, your thoughts, your comments this morning.
Well, thank you, Jim. And it truly is so sweet to hear you say that because you are so insightful. Our callers constantly talk about it, so thank you for the opportunity. One thing that I feel a lot of places are not covering about this story with Tree of Life is why Tree of Life was selected by this killer. And Tree of Life was selected by this killer because of the fact that it had recently hosted a Shabbat, which is a Friday night, into Saturday morning and Saturday evening holiday that Jews have every week. During a Shabbat service, they had recently raised money for HIAS, H-I-A-S, which is the Hebrew Immigrant Aid Society, which was founded in 1881. And I think it's important to highlight that this place of worship was selected because this person felt that Jews were responsible for bringing immigrants, refugees, people this person found distasteful into this country. So if your heart has been moved by the story of Tree of Life, I would encourage you to look into HIAS. It's been around since 1881. It still exists to help refugees and immigrants. And the same week that they had their HIAS Shabbat, my community in Milwaukee had ours. So it hits close when you know that any of us could have been selected because of our choice to remain connected with this community organization that wants to help people around the world. So it hurts that I haven't heard other outlets cover it, and I just wanted to throw that out there. So back to you, Jim.
Anya, thank you so very much for that insightful perspective on this story. Again, lots of aspects here to this. Undeniably, Robert Bowers, motivated by hate, by a sense of the other, and again, specifically, as you indicated, selecting this particular venue, this place of service, this place of engagement, this place of humanity for a purpose. And not only do we stop him from doing that, we send the message, as Anya, your important words say this morning, to other people, that if you do this kind of thing, not only is it intolerable, we talk a lot about the importance of language and conveying that, but you will be stopped. And in this case, because of the things that he did, the federal government has decided through the process of justice to impose the death penalty upon him, making that selection, as Anya said, for a reason, for a purpose, targeting this particular community, this particular congregation. Anya, thank you so much for that insight, that perspective, as we continue to talk, as we will down the road also, about not only guns in America, but these kinds of things, identifying people who are perceived inappropriately, wrongly, as the other, as people who are not a part of our community, and the responses that we should and necessarily need to pursue against all of them. Anya, thank you so much for that. Promised this morning that we would chat about some other, what I'm calling rule of law snapshots, but all of them come again in the wake of the big news story this past week having to do with the return of an indictment, another indictment, the fourth criminal indictment against our former president. We're going to talk a little bit about that and then move to these other snapshot stories that are also related to these 4 indictments and other matters pending against our former president. And then, as I said, in the latter portion of our first hour into the next hour, we're going to return to that January 6th indictment that we began to talk about last week, this important and charging document coming out of Washington, D.C., alleging federal offenses against a singular defendant. His name, of course, is Donald John Trump. We know that just this past Monday, a grand jury sitting in the state of Georgia indicted Donald Trump and 18 other people named in the indictment in this sprawling racketeering investigation, this sprawling racketeering charge, if you will, multi-pronged effort described in this indictment to overturn the narrow election loss in Georgia that he suffered in 2020. He's now facing, as we well know, 4 separate criminal charges. This indictment laying out the most broad set of accusations against the former president, 13 counts, including racketeering, making false statements, and pressuring public officials to violate their oath of office, among those charged in this 41-count indictment. The culmination, again, of this about 2.5-year investigation in Fulton County, led by the DA there. Her name is Fani Willis, also involving the former White House Chief of Staff, Mark Meadows, and a great number of lawyers, which we're going to talk about at some point down the road as well, including Rudy Giuliani, John Eastman, Ken Chesbrough, Jenna Ellis, and Sidney Powell. All these lawyers, once again, involved in this. When we come back after this break, talking a little bit more about that, and then providing some other information about big stories this past week before we get back to that January 6th indictment coming out of the Federal District Court in D.C. Stay with us for this important discussion. We are back this morning. It is Saturday, August 19th. This is Morning Cannolis, and we're spending much of our first hour talking about various stories coming out of the rule of law environment in our nation. Right now, chatting about this major fourth indictment against our former president, Donald Trump, coming out of Georgia. The state prosecutor there, Fani Willis, coming out of Fulton County, and a state grand jury returning this massive indictment against Donald Trump and others for their involvement in trying to undermine, to overthrow the election results in 2020 there in Georgia. Recall well that Fani Willis, the DA there, is looking into whether Mr. Trump and associates there violated Georgia law, and particularly bringing this charge under RICO, the Racketeer Influenced and Corrupt Organizations Act, a state law that also has a federal parallel law to it as well, basically saying that you've got an enterprise, a criminal enterprise of people who've gotten together for a common purpose, sort of like a conspiracy, but again, under state law, alleging that their common purpose here was to once again interfere with the counting of votes, the proper election, the voting in Georgia more generally in this sprawling indictment, did various things along the way, all of those set forth at great length in this indictment. And what brings them together again is this common mission, this common purpose to accomplish fraud in Georgia. And that's what brings it together under RICO, a statute often used in the past, in years past, to go after so-called mobsters in our nation, but used more and more to identify enterprises of a white-collar nature, including this, when you've got this, again, consorted group of people, this enterprise put together, brought together, coming together to accomplish some inappropriate criminal and illegal criminal result. That's exactly what she is identified here in that indictment. This investigation, of course, began shortly after this recording was released, in which Donald Trump was talking to Brad Raffensperger, who is the Georgia Secretary of State. That was happening on January 2nd of 2021, well over 2 years ago. And you may recall well that during that call, Donald Trump insisted that he won the state of Georgia in the election, made baseless allegations of fraud, which are also a part of the indictment, even though multiple recounts confirmed that he had lost. And Trump told Raffensperger at that time that he wanted to find, Trump wanted to find 11,780 votes, one more than he needed to win Georgia and its electoral college votes. No doubt, Georgia, among 6 other states, including Wisconsin, a lot of focus of the former president and now the named co-conspirators in that state case to try to reverse the results of the 2020 election. Over time, we became clear that this investigation in Georgia, like the investigation in the federal system as well, also pursuing false statements that lawyers made for and on behalf of the former president in state legislative hearings there in Georgia. A meeting about 16 pro-Trump Republicans who cast these bogus or false or fake electoral college votes for him, much as they did in these other states, including here in the state of Wisconsin. There was an intimidation campaign against a pair of Fulton County County election workers. We will talk about them in a future broadcast as well, falsely accusing them of fraud, changing their lives, exposing them to the possibility and the terror, if you will, of people who are going after them because of these allegations, completely unfounded, that they engaged in some kind of voter fraud there. And a successful effort by some Trump allies there in Georgia also to copy sensitive software. An elections officer we haven't heard a lot about before in rural Coffee County, Georgia, about 200 miles away from Atlanta. All of that in this massive, huge indictment coming out of Georgia this past week. Again, alleging election fraud, forgery, false statements, impersonating public officers, soliciting public officers to violate their oath of office, this pro-Trump electors scheme, conspiracy to steal votes, this voter data, again, in Coffee County, and the harassment and intimidation of these election workers. We know them as Ruby Freeman and Shay Moss. They testified as well before the House committee looking at all of this too. Mark Meadows, as I said before the break, significantly among those people who are specifically named in this indictment, charged in this indictment, and a lot more to come, including in our next broadcast next Saturday, an in-depth review of exactly some of the stories, the accounts that animate those charges, the RICO charges and the many other charges in that indictment. Donald Trump himself, again, charged in 13 different charges in that document: solicitation of violation of oath by a public officer, conspiracy to commit forgery, conspiracy to commit false statements themselves, conspiracy to commit impersonating a public officer, and conspiracy to commit filing false documents, in addition to this major count, the violation of the Georgia RICO Act. And again, a lot of discussion, a lot of in-depth review of exactly the stories, the accounts in that, again, speaking indictment. We're going to talk about in our next broadcast and invite you to tune in and be a part of that discussion then. In the wake of that, what has happened? What has happened in Georgia in the wake of that indictment announcement of earlier this week? One of the things that regrettably is not only contrary to the rule of law, but is becoming more commonplace, I would offer in large part because of the statements being made by our former president in the public domain about the things that should happen to people who provide evidence, who come before a grand jury, who provide information to a trial jury, witnesses, other people with relevant facts that prosecutors and investigators have to sift through to determine whether or not there should be charges. And sure enough, just this past week, we have learned, as late as yesterday, not only are there threats being made against Fani Willis, the DA in Fulton County, plainly trying to intimidate her, trying to get her to stop this prosecution. That will not happen. That will not happen because not only is she committed to this prosecution, but the reality is that just by stopping a prosecutor alone, individually, does not prevent a case from going forward. But second, just as concerning as that, if not more concerning, threats against the very grand jurors whose names are under Georgia law released in the public domain, threats against the grand jurors who returned this indictment, who did their job, who came in, the people from the community who listened to the months and weeks and great number of hours of testimony, reviewed documents, did their civic duty. Threats now brought against them as well, likewise being investigated, their addresses, their home addresses, posted on social media, again, as an attempt to intimidate them, to send messages to people down the road that if indeed you do your job, you do what you need to do as a citizen, we will go after you. And where does that come from? The allegations of misconduct, completely unfounded, against these good people, against the prosecutor, and also by the Fulton County Sheriff, Pat Levatt, who's also there, also getting threats as he is planning for the initial appearances by Donald Trump and other defendants there in Georgia. All of these people now the subject of threats and threats of violence against them. Wildly inappropriate, and in and of themselves can in fact form the basis, certainly for federal charges, state charges as well, under Georgia law. What do we know about what has happened in particular, and what is the story that comes out of one of those attempts not only to address what's going on in Georgia, but also a similar threat made by a Texas woman against the judge who's presiding over the federal case. This is not the Georgia case, now the federal case that we've begun to talk about, also alleging a 4 counts against the defendant, Donald Trump, in that federal indictment pending in the District of Columbia. Texas woman, again, presumably taking up once again the invitation by our former president. He posts on social media about a week or so ago. He says, "If you go after me, I'm coming after you." That's the invitation. That is the invitation that Donald Trump sends to America, which in and of itself is not only a threat, an invitation to that kind of behavior, but should be the premise for not only additional review by the presiding judge, but also the basis for criminal charges for threatening witnesses, threatening people who are involved in this process. This past week, a Texas woman, her name is Abigail Jo Shry, S-H-R-Y. She lives in Alvin, Texas, was charged with threatening to kill Tanya Chutkan. She is the federal judge in Washington who's overseeing Donald Trump's prosecution again in this federal case, seeking, again, criminal remedies against him based upon his efforts to overturn the 2020 election, kind of the parallel case that we're talking about there in Georgia. Again, Abigail Jo Shry. She called Judge Chutkan's chambers on August 5th, 2 days after Trump was arraigned in that federal case on the election interference charges, and she left a voicemail attacking the judge, who is black, with a racial slur, according to a complaint that was filed and released just yesterday. And in the message, Ms. Shry told Judge Chutkan again, very much at the invitation of our former president. She said this: "If Trump doesn't get elected in 2024, those are also the that regrettably are being hurled at the grand jurors, at the law enforcement authority are engaged office in Georgia as well, because of the legitimacy of the process in which these people are engaging right now." You know well that last week Judge Chutkan addressed this very issue. She warned Donald Trump that she'd take measures to ensure that he did not make inflammatory statements about the case in a way that might intimidate witnesses. This exactly what happening, otherwise harming the integrity of these proceedings. The federal agents, in the wake of Abigail Shry's hurling this threat to Judge Chutkan, went to visit her, as they always do, about 3 days after she left that message, and she admitted she had called the judge's chambers. She told the agents that she had no plans to go to Washington, D.C. or to Houston, the area that one of her representatives represents. She had also filed and submitted and hurled a threat against her congressional representative at the same time. She said that if Sheila Jackson Lee, who is that representative, comes to Alvin, then we need to worry, according to that complaint. Significantly, again, the sense of deterrence out there, the message conveyed by what law enforcement does when you engage in threats against people who are involved illegitimately in the law enforcement system. What happens is Ms. Shry yesterday was this past week denied bail, ordered to be held in custody for 30 days following her detention in Houston. Significantly, Ms. Shry's father, Mark Shry, testified that she was a non-violent alcoholic, those words, who sits on her couch daily watching the news while drinking too many beers. Mr. Shry told a judge in Texas that she often became agitated by the news, started calling people and threatening them. That, according to the complaint, they're coming out of South Texas. That may well be the motivation. The intent, plainly, is to threaten. It is appropriately responded to by prosecutions, by apprehensions, and by bringing those people into the federal and state criminal justice system as a way not only of deterring them, stopping them from doing these things in the future, but also deterring others who would, again, take up what is undeniably the invitation of our former president, now facing these 4 completely separate but related charges in various jurisdictions, alleging crimes against the people of various states, New York and Georgia, and crimes against the people of the United States of America as well. If you go after me, I'm coming after you. That kind of behavior, that kind of conduct itself, from my perspective, should not only result in a clear and unequivocal response by the federal judge, but could itself be the premise for yet more charges as Donald Trump continues to do this attack socially in public social media against the people who are prosecuting him based upon his conduct. And so let's talk more about that as well. We know that in the wake of that indictment of the January 6th event, more events happening related to the prosecution there in Washington, D.C. John Eastman, again, and others also prosecuted in Georgia. John Eastman, one of the attorneys in the Georgia prosecution, he wants to be severed from the others. He says basically that because he was less culpable than the others, identified the other 18 in that indictment, his case should be tried separately from the others. This happening, John Eastman, at the same time that he's facing a disbarment trial in California. Prosecutors there indicating that they are not going to suspend that trial in California, even while the case is pending against John Eastman and others in Georgia. When we come back, a little bit more discussion about other things coming out of Georgia, coming out of Washington, D.C., and then a return to our discussion of the January 6th federal indictment out of the federal district court in Washington, D.C. And we are back this morning on Morning Cannolis. My name is Jim Santel. We're spending much of this first hour talking about various rule of law snapshots, almost all of them, not exclusively, but many of them related to the charges now pending against our former president in 4 different cases, 2 of them federal, 2 of them state, principally, but not exclusively, involving the events of January 6th. And right before the break, talking in particular about this latest indictment of just this past week coming out of Georgia. It is a state criminal prosecution, this sprawling indictment against Donald Trump and 18 others involving, among other things, RICO charges, racketeer-influenced and corrupt organization, a variety of different kinds of packages, pockets, if you will, of prosecution units in that case. Fani Willis telling us after the indictment was returned a couple of things, and that is she anticipates that all of the 19 defendants will make their initial appearances there in state court, as they should, prior to the end of this month. Donald Trump indicating through his counsel that he will likely surrender and, yes, in fact, be booked and perhaps even a mugshot taken of him for the first time in any of these cases. The feds have previously declined to do that. That's probably going to be happening this coming Thursday or Friday, the 24th or 25th, and all of them, all 19 coming in to get processed. The sheriff, again, indicating that he is going to treat all of these defendants just like any other defendant would be. That is the way it should be done. No special consideration for anyone. Not treated worse, not treated better than anyone else in our federal system, our state system. That is going to be happening this coming week. We know in addition to that, other events having to do with these other defendants in that state prosecution. Fani Willis indicating that she would like to bring them all to trial fairly soon, on about 6 months or so. And March 4th of 2024. She would like to bring all of the defendants into state court. She has indicated she'd like to try all of them together. We'll see whether that happens. And indeed, as I said, we've already got a request from John Eastman, perhaps others, to be severed from the others. That will probably happen for a variety of different reasons, perhaps including various pleas entered by some of the defendants as they recognize that their exposure, many of them 5 years, more than that, up to 20 years in prison for some of the things that are charged in that indictment. In addition, we've got others who are indicating, including Mark Meadows, they'd like to transfer the case from state court into federal court. Let's talk about that for just a moment or so. Highly unlikely that will happen. There are circumstances where a state prosecution can, in fact, be transferred into a federal venue, typically in the civil area, where it's determined that the underlying events, the underlying activities by defendants who were a part of the federal government acting in their scope of their duties and responsibilities, that those should be prosecuted in federal court because of the nature of their duties. Things done in the scope of their employment, duties and responsibilities kind of under cover of their federal responsibilities. Here, unlikely that will happen. Why? Difficult to maintain that these kinds of things that are alleged in this state indictment are things done in furtherance of a legitimate government pursuit of duties and responsibilities. Beyond that, even if it were to move into federal court, it's not as if the case changes. Fani Willis would then be prosecuting this case in federal court. Different courthouse, different location, but same charges, simply in a different venue. Again, highly unlikely that will happen. Will almost certainly remain in the state court where it should. That's where the interests of the people of the state of Georgia are best vindicated by virtue of this state prosecution against Donald Trump and the 18 others, including people like John Eastman and Rudy Giuliani, and yes, Sidney Powell and Jeffrey Clark and Kenneth Chesbrough. Kenneth Chesbrough, one of the people also named with particularity in the Georgia indictment. He and some of the others identified as unindicted co-conspirators in the federal case in Washington, D.C. But here in Georgia, Fani Willis and the grand jury that returned this indictment based upon probable cause to believe that all of this has happened. Here, we got some additional information about Ken Chesbrough. He's identified plainly in the indictment as one of the major movers and shakers, identified as a co-defendant along with Donald Trump and the others for all of these acts, also charged with the RICO violation in that case. And up to now, there's been an awful lot of analysis about the so-called suits versus boots, kind of a casual way of describing a very serious matter here. Those people who are in charge of putting together the overall scheme, the conspiracy to bring people together to undermine our election, the people who might be sitting behind desks, putting together memorandums and protocols, all illegal to try to overturn the election results of 2020. Those are regarded again sometimes as the suits in these enterprises, and the boots, the people on the ground, the people who actually stormed the Capitol on that day. About 1,000 people now under either investigation or prosecution, many of them convicted to this point. The boots on the ground. And there's always been sort of this divide. And the question has always been, gee, is there a clear connection between those people who organized this and put it in place, put together this multifaceted scheme, which again is a part of the federal investigation and federal prosecution, and also set forth in the Georgia prosecution as well? Is there a connection between those people who organized this, came together to draw the strings and make the tendrils between their organization and the people brought to Washington, D.C.? Well, there was some significant information about that just yesterday. It came through the nature of some videotape showing Ken Chesbrough. Ken Chesbrough, again, one of the 6 unindicted co-conspirators in the January 6th indictment federally, but also named with particularity among the 19 defendants in Georgia. We've got videotape now of Ken Chesbrough, who, again, one of the principal authors, as we will hear again in our second hour, of this so-called Wisconsin memorandum, other memorandums to put together the fake electors scheme and otherwise try to get Donald Trump to remain in power in the wake of the 2020 election. He is certainly one of the lawyers who is at the core of this conspiracy, this scheme, as Fani Willis describes it, as a RICO violation. He's walking around on the grounds on January 6th. He is there at the time that the others, hundreds, approaching 1,000 other people, are attacking the Capitol and moving in. No indication that he himself went inside the Capitol. There may be an indication he was in a forbidden area, if you will, a place where people should not have been that day, which could be a low-level charge against him. But it's the first time we've got a connection, again, between him and the people that he was associated with, including the former president and others, and actual people on the ground. We see him in the company of Alex Jones there on the grounds of the Capitol, and we also see him plainly in the company of many other people there on the grounds of the January 6th assault on the Capitol that day. Why is that significant? It shows once again this linkage between the lawyers and the violence. The people who put this together and the people who perpetrated it on January 6th. When we come back after our first hour break here, I'm going to talk about one other matter related to the January 6th prosecution, and that is the Proud Boys. And then we're going to go back to that major grand jury indictment in the federal district court. Stay with us in our second hour coming up here on Morning Cannolis.
Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
Good morning once again. This is our second hour on Saturday, August 19th, 2023. This is our weekly review, our analysis, and our discussion of those most important events and stories in law and government and justice in America. We're spending most of our day today, including our first hour and now our second hour, talking about these rule of law snapshots, most of them related to prosecutions of the former defendant, Donald Trump, for violations of federal and state law coming out of Georgia just this past week. This multi-count sprawling indictment under RICO and other state charges alleging this scheme, this RICO-premised attempt to undermine the counting of votes there, the voting itself, and making all sorts of false statements, false representations, other things set forth in that indictment, and then turning back to the January 6th indictment coming out of the U.S. District Court, the U.S. grand jury in Washington, D.C., alleging again in 4 counts against the singular defendant there in Washington, D.C., his name again, Donald Trump. In the wake of all of that, that is these 4 different prosecutions, 2 of them state, 2 of them federal, the other federal case, of course, being the Mar-a-Lago documents case, which we've talked about in the past. In the midst of all of that, some other significant events happening just this past week, right before the break at the top of the hour, talking about the identification of Ken Chesebro, one of the lawyers involved in putting together the scheme to overthrow the 2020 election, always identified up to now as being on the desk side, if you will, the organizing, the conspiracy side of these allegations, identified just yesterday as being on the ground with the boots, so to speak, on January 6th, walking around there in the company of Alex Jones, again, this great conspiracy perpetrator, not only with respect to many, many matters in America, but also focusing upon shootings in America and other matters that are a part of our public consumption here. Alex Jones there on the ground. Other people on the ground that day, including the people, the associates, the affiliates of a group called the Proud Boys. We've talked about them before. In addition to the Proud Boys being this nationalist, anti-government group identified by the government, prosecuted successfully by the U.S. Department of Justice for seditious conspiracy. The other group also out there, Stuart Rhodes and his folks, the Oath Keepers, similarly prosecuted seditious conspiracy for the events of January 6th on the ground on that day. We know that Stuart Rhodes and others receiving significant sentences by the federal district courts in Washington, D.C. Stuart Rhodes received 18 years imprisonment. That's his term. He's on appeal right now to the U.S. Court of Appeals for the District of Columbia Circuit. But that sentence likely to be upheld in the future. Just this past week, the Department of Justice anticipating the much related sentencing of the other major defendant in charge of the Proud Boys. His name is Enrique Tarrio. We have talked about him at great length in the past. Department of Justice announcing it is going to seek a prison term for Enrique Tarrio of 33 years in federal prison. 33 years in federal prison. If we come anywhere near to that, if the judge who's presiding over the case comes anywhere near to that amount, that will be the most lengthy sentence ever imposed upon any of the 1,000-plus defendants, including those on the ground, other circumstances, Proud Boys, Oath Keepers, out there to this point. And what is the reason for that? And why do I bring that up? Again, anticipating the sentencing of Enrique Tarrio in the near future. Why is the announcement by the Department of Justice of that huge sentence request significant? It is important because of what we've talked about at great length here on this broadcast, and that is the notion of deterrence. Yes, indeed, you want to deter Enrique Tarrio and all the others. They have been convicted, they were sentenced, they will spend significant periods of time in prison, as will the other members of the Oath Keepers, as will many of the other non-affiliated defendants, also the subject of these prosecutions coming out of Washington, D.C. The message, however, is not only about them, but to other people down the road who might think about assaulting not only a federal enclave like our capital, the place of justice, the place of representative government, the symbol of our republic, but sending the people the message that if you do this, if you engage in this kind of behavior, we'll stop you, we'll deter you from doing it, but also sending the larger message of deterrence to America, that this conduct will in fact bring you into the scope of federal prosecution, and you will go away to jail for long, long periods of time. This is no small request. It is almost unprecedented in the history of the U.S. Department of Justice, and we'll see what the federal judge does in this case. But anticipating that, again, this major news coming out of Washington, D.C., that the Department of Justice is seeking this extraordinarily high penalty against Enrique Tarrio, responsible kind of as a mid-level person, not there on January 6th, actually in Baltimore, but playing the organizing people on the ground, the boots on the ground, kind of this mid-level person between the people attacking the Capitol, going in, and once again, the people who are organizing it at a higher level. And that brings us once again to the people like Ken Chesebro and John Eastman and Sidney Powell and Jeffrey Clark and Boris Epshteyn, again, this sixth person identified as an unindicted co-conspirator in the federal indictment in Washington, D.C. Of course, the number one unindicted co-conspirator there in that federal case, Rudy Giuliani. All of those people, with the exception of Boris Epshteyn, also named by name in the Georgia indictment as well, among the 19 people specifically identified in that Georgia indictment, identified by virtue of what they did in the federal indictment, alleging once again violations of the federal law in connection with the January 6th event and the attempt to overthrow our republic and undermine the counting of votes on January 6th. So let's turn to that indictment. We talked previously about principal aspects of that indictment, specifically noting some things that were set forth in the indictment presented to America in the wake of this grand jury process going on for many weeks and months in the U.S. District Court in Washington, D.C. Before we get back into that, to resume our conversation of last broadcast, I want to reaffirm how this comes about, what a grand jury is, to address some of the issues that continue to be out there about not only the Georgia prosecution, which also comes out of a state grand jury, actually two of them there, but a federal grand jury. Who are they? Where those people come from? They are people who are pulled in just as others would be for a trial jury, a trial of a criminal case, of a civil case. They're you and me. They are not prosecutors. They are not investigators. They are bankers. They are educators. They are masons. They're healthcare providers. They're entertainers. They're all kinds of people out there who are called in to determine whether or not there's probable cause to find that an indictment, charges should be issued on particular counts. And that's what they did in both of these cases coming out of Georgia and then also in Washington, D.C. Indicate as well that a similar analysis goes forward with respect to the Mar-a-Lago grand jury They also reviewed evidence. And likewise in New York, that case involving the fraudulent documents and the attempt to undermine the 2016 election by paying off Stormy Daniels. That's still pending in New York. All of those things looked at by people who are impartial, not the prosecutors, not the investigators themselves, plainly endorsed by the prosecutors and now responsible for bringing these cases to trial, but a result of this independent review undertaken in the federal district court in Washington, D.C. by 26 people assigned responsibility for reviewing the evidence presented to them. Significantly, one more comment about a grand jury before we launch back into the content of the indictment itself, and that is this. The grand jury is not an agency, not an office of the U.S. Department of Justice. It is not. It is a branch, it is a subunit, if you will, of what? The United States courts. It's a different branch of government. And so when there are grand juries that are impaneled here in eastern Wisconsin and western Wisconsin, and many of the other districts, all of the other federal districts in the United States of America, they are a part of the courts. They are not a part of the executive branch. They are not a part of the Department of Justice. And indeed, they're selected by judges, federal judges and federal magistrates in those particular districts that bring them together, that commission them, that give them their oath of office, that tell them that, yes, indeed, they're going to be reviewing evidence for as much as 18 months, maybe even more. This independent entity, not a part of the Department of Justice, brought in people, a community of peers, if you will, who decide whether or not charges will be brought. And that's the genesis. That's the basis for this indictment that we began to look at last time, and again, reviewing once again today as we go into this process. Before we do that, we do have one caller on the line. We appreciate your calls, of course, throughout this hour and future broadcasts as well on all of these issues. Dana, thanks for joining us this morning from La Crosse. Glad to have you with us.
Good morning, Jim. Happy Saturday to you.
Happy Saturday to you, too.
Back. Say, I'm glad you're touching on a lot of the co-conspirators because we know who Donald Trump is. We know his involvement. My question, with the knowledge that we do have on who the co-conspirators are that are identified already in all these different cases, but like, for instance, Fannie Willis, she's got the 19 indicted co-conspirators, and then there's 30 more that aren't named.
Right.
And and first question, are we going to learn who those 30 people are? Is there possible indictments coming for them? But the main crux of my question, Jim, is based on what we know and who a lot of these people that are involved, and maybe not all have been indicated yet. I want to know, should Ron Johnson be worried legitimately? Is justice going to be coming for him eventually? The guy is as crooked as the day is long, and we need to get him.
Very good. All right. So a couple of things to unpack there, Dana. Thank you, as always, for your good questions. Let's talk about some of that. We've got these unindicted co-conspirators. What we know who they are, the 6 people there in the federal case. You're absolutely right. We have got about almost 30 unnamed, unindicted co-conspirators, in addition to the 19 in Georgia. Right after this break, I'm going to take up those 2 questions and talk more about intent, talk more about the possibility of future indictments, not only in the federal system, in the state system, and take up your very good questions about who those 30 people are and who other defendants might be out there, arguably including members of the United States Congress. Stay with us for answers to those very good questions from our great caller this morning. We are back here on Morning Cannolis, responding to a terrific set of questions offered by Dana just before the break, indicating in particular he's got some interest, as you all do, as I do as well, in what's going to happen to unindicted co-conspirators, named co-conspirators, other people who might be involved in these schemes, charged now as a RICO violation in Georgia under state law, but again charged in the federal district court in Washington, D.C. under a number of different charges, including conspiracy to defraud the United States, are conspiracies related to the obstruction of voting certification, that, of course, the counting of votes by the Speaker of the House of Representatives and the Vice President, and significantly, conspiracy to violate the civil rights of Americans. That is your right to a proper and fair and decent election where your votes are indeed counted. And so Dana asking a lot about, we're going to find out who some of these other unindicted co-conspirators are. We know them coming out of the Georgia indictment because many of them, again, affiliated with people identified with the 19. Highly likely, as this case goes to trial, whenever it goes to trial, that as evidence of those particular events set forth in great detail in that indictment coming out of Georgia, that there will be evidence in court about who they are. A lot of what happens right now is that discovery is produced, information is produced to the defendants in the Georgia case, also in the federal case, including the former president. And in all of that, with great clarity, the names and identities and the involvement of those unnamed, unindicted co-conspirators is there. And so defendants can see it, their attorneys can see it. That's part of our process. That's what we should be doing, in fact, whenever we engage in these criminal prosecutions. Presumption of innocence attends all defendants, and they get a right. They get a right to know the charges against them and the kinds of things that are going to be presented at trial. So defendants are told, and again, highly likely that during the course of a trial, could also be during the course of pretrial proceedings with respect to a motion to dismiss, a motion to suppress. Some of that information can come out in the public domain, but generally not released until some public proceeding, some judicial proceeding in which those things are publicly disclosed. And so the other good question coming out of our last caller, also asking about other people out there, including members of Congress, arguably our own senior senator here in the state of Wisconsin. What about their exposure? What kinds of things might still be possible out there? And the answer, of course, is we know well that Jack Smith, the special counsel, indicted in this very narrow but compelling indictment one defendant, and his name is Donald Trump. He identified, obviously, 6 others, but the text of that overall indictment, which we're going to get into in a little bit greater detail, coming up shortly. The text of that also indicates an awful lot of other people involved in this process. And the narrow answer to your question is, of course, the decision about charging other people within the discretion of what a grand jury, once again, presented with evidence of involvement. Grand juries look not only to the people who actually did the events that are the subject of the substantive counts in indictment, but you can also look at people who aided and abetted. It's called Section 2 culpability, people who supported this in some way, who provided some mechanisms, and of course thinking specifically about people in Congress, arguably our senior senator, who may have done things likewise to promote what happened on January 6th, and maybe even before and after. All of that presented to a grand jury. Highly likely that the names of many people in Congress are on folders, whether they're electronic or paper folders, in Main Justice, who are being looked at for their involvement, and you make determinations, make recommendations, certainly the grand jury, about whether or not the evidence is compelling enough. The grand jury, again, determines whether there's probable cause to believe that someone that's in Congress or someplace else was responsible in some supportive way for doing something that supported this overall initiative to try to overthrow our election, and determining then if down the road the government can produce evidence beyond a reasonable doubt that that person did indeed aid and abet, support, or was somehow involved directly in a conspiracy, an agreement to overthrow. And those are the questions. Those are the kinds of things that grand juries will take a look at and determine whether people will be indicted well beyond those folks indicted to date. Strong anticipation that Jack Smith, not only while this case against Donald Trump federally is pending, will indict the others we had identified as unindicted co-conspirators, and probably people even beyond those specifically identified in that grand jury indictment. So great questions, great thoughts. Appreciate those comments and the callers always. The broad answer, of course, is what is this allegation? What are the 4 counts in the indictment all about? Purpose of the conspiracy to overturn the legitimate results of the 2020 presidential election by using knowingly false claims of election fraud to obstruct the federal government function by which those results are collected, counted, and certified. We talked about that the last time, and in particular, talked about the ways in which the defendant, Donald Trump, he's a singular defendant, unlike the indictment in Georgia, which is broad, alleging in very, very broad and sweeping terms many, many aspects of this. The federal indictment, again, telling this very compelling story, but identifying to this point only one defendant, Donald Trump. And one of the questions, of course, comes out of this is, what did he believe? What did he honestly know? Did he understand, as it sets forth in this indictment, that the claims he was making about the 2020 election were false and fraudulent, and that he knew they were false? And that's a principal aspect of this indictment. It speaks to us from virtually every page of this indictment. The establishment of what's called scienter, mens rea, understanding that what you're doing is for a criminal purpose. Donald Trump probably going to maintain during the course of his trial, whenever that happens. Jack Smith wants it to start in early January. Unlikely that date will stick. But nonetheless, whenever it happens down the road, one of the things that's required for the government to show is that Donald Trump not only did these kinds of things, but he did them for a corrupt motive, corrupt intent. When we come back after this break, we're going to talk about some of the information in the indictment. Again, charges, not convicted statements here, but charges against him that suggest very strongly that he knew what he was doing was wrong, that he had this intent, and that Jack Smith will be able to present this to a trial jury, just as he did to a grand jury, and get a conviction for the knowing and purposeful, intentional attempt to overthrow our election. Stay with us for that discussion right after this break. And we are back this morning. Thank you for once again joining me as we continue to talk about this major indictment, this federal indictment of a number of weeks ago, a 45-page indictment returned by a federal grand jury in Washington, D.C., a part of the court system, alleging in 4 different counts that Donald Trump conspired to defraud the United States of America, obstruct the voting certification proceedings, and conspired to violate our civil rights in connection with the January 6 events and things both before and after that. One of the principal focuses of the indictment, again, this federal indictment, still pending, coming up for a trial at some point in our nation's future, was that the defendant, Donald Trump, knew, in fact, that the things he was saying out there were false. And why is that important to establish? It's important because in order to create and to establish for members of the trial jury a clear understanding and enable them to embrace the notion that Donald Trump knew that he was doing this for a corrupt intent, got to be able to establish that he knew his claims were false. The things he was saying out there in the public domain were unsupported by anything that he was hearing, anything that could justify his purported defense that he truly understood that the election had been stolen. No basis for doing that. And in fact, the reason for the charges against him, the basis for it, the theory is that he's saying all these things not to preserve the legitimacy of our government, the future of the republic, as he sometimes hints, but rather simply to stay in power. And that's why these intent statements, that's why all this about scienter and what he knew, what he understands at the time and still understands to this day are so important. In the indictment, again, the claims he's making are false. He knew they were false, and he acted corruptly to accomplish this thing that would undermine our republic. In fact, the indictment goes on to say he was notified repeatedly that his claims were untrue, often by the people on whom he relied for candid advice on important matters and who were best positioned to know the facts. Again, that coming from the indictment specifically. Let me identify some of those to underscore this all-important issue about what he knew, what he understood, and the fact that any defense premised upon his belief somehow that he didn't get it, that he truly believed that the 2020 election had gone in his favor, that the election had in fact been stolen from him, was simply unsupported and not true, and indeed that he knew that to be the case. He knew he was lying to America. Why? Because of all these things set forth in this indictment. Among them, defendant's vice president, we know his name, obviously Mike Pence, personally stood to gain by remaining in office as a part of Donald Trump's ticket, and whom the president asked to study fraud allegations, told Donald Trump that he had seen no evidence of an outcome determinative fraud. In other words, nothing in Mike Pence's view, his examination of this, suggested anything other than that the Trump-Pence ticket had lost. And he said that to the president. Senior leaders of the Justice Department, again, a very important part of this indictment, appointed by Donald Trump and responsible for investigating credible allegations of these election crimes, told Donald Trump on multiple occasions that various allegations he was making of fraud were completely unsupported. Once again, telling him directly. The director of national intelligence disabused the former president of the notion that the intelligence community's findings regarding foreign intelligence would change the outcome of the election. Nothing about the intelligence supported that as well. Department of Homeland Security, their Cybersecurity and Infrastructure Security Agency called CISA, likewise, indicating there was no support whatsoever that the 2020 election had been stolen. It was, in fact, the most secure election in history, according to CISA, and they told Donald Trump exactly that. Days later, according to the indictment, after the CISA director, whom, again, Donald Trump had appointed, this is Donald Trump's own person, announced publicly that election security experts were in agreement with him that claims of computer-based election fraud were unsubstantiated, and based upon that, Donald Trump fired him. That's what the allegations in the complaint are all about. Senior White House attorneys, likewise, telling the defendant, disabusing him completely of this view that he had won the election, selected by him to serve as his aides and his assistants, informed Donald Trump no evidence of an outcome determinative election fraud, told him that his presidency would end on Inauguration Day in 2020. All of these clear signals to the president and establishing once again that he knew what the truth was. And there was nothing about anything in his own mind that would indicate that indeed he had won the election, and therefore his efforts to overturn these purportedly false reports and false results of the Electoral College were justified in any way. Senior staffers on the defense 2020 election campaign, according to the indictment, likewise, sole mission was to ensure his reelection, told Donald Trump on November 7th, 2020, that he had only a 5 to 10% chance of prevailing in the election. Success was contingent on Donald Trump winning ongoing vote counts or litigation where? In Arizona, Georgia, and yes, Wisconsin. And within a week of that assessment, Donald Trump, of course, lost in Arizona, lost in Wisconsin, meaning that he had lost the election. He knew that as well. State legislators and officials, again, many of those in Donald Trump's political sphere, if you will, voted for him, wanted him to be reelected. Repeatedly told Donald Trump that his claims of fraud in their states were completely unsubstantiated, false, and resisted his pressure to act based upon those. And of course, the indictment also identifies these many state courts, federal courts, the neutral arbiters, the indictment says, responsible for ensuring the fair and even-handed administration of election laws, rejected every outcome determinative post-election lawsuit filed by Donald Trump, his co-conspirators, in this federal indictment, and his allies, providing Donald Trump with real-time notice that his allegations were meritless, further supporting this notion that there is no basis to go out there and state, as he repeatedly did, that the election had been stolen from him, and that in these various states, the fraud was continuing. Again, why is that significant? It goes to this issue of intent, showing that the defendants, Donald Trump's purpose was not to ensure the republic, not to ensure the integrity of the process, but simply to remain in power, knowing knowing that he had no basis whatsoever to do so. All of that coming from the knowledge piece, the intent piece in this indictment, going to loom large in the presentation of this case in front of the trial jury. The other issue, of course, which we talked about last week, was this sort of related defense we're seeing, a First Amendment violation, saying that he had the right to go out there and advocate and say these things about the 2020 election. Of course, as we talked last week, paragraph 3 of the indictment right up front addresses this issue. The grand jury says, you know what, Donald Trump, you got a right to say those things. You've got a right to go out there and maintain that you did, in fact, win the election. That's your First Amendment right. You don't have the right. What you don't have the right to do is commit crimes. You don't have the right to commit violations of the civil rights laws, to obstruct the certification of voting, to defraud the United States. And you did all that, again, with the intent to undermine the election. That's what this indictment is about. And that's why the First Amendment allegation, the First Amendment position, if you will, that he was somehow simply vindicating his First Amendment rights is completely meritless and will also fail in the trial of this case, as will any attempt to show that Donald Trump truly believed that he'd won the election. Just the opposite. The indictment speaks loudly and clearly on every page of its text, and it continues to be, of course, the focus of the continuing prosecution by Jack Smith and others in his office. We've got another caller on the line. Mark, appreciate your comment, your question this morning as we continue our march through the indictments, not only in Georgia, but also now in the U.S. District Court in the District of Columbia. Mark, your comment or question.
Yeah, I was hearing all the comments, especially I appreciate Dana's comment from La Crosse. That it occurs to me that all these people that were involved in this were all in violation of their oath of office. They're not taking an oath to do certain things according to the law. And of course they are by implication, but they're supposed to be protecting and defending and adhering to the constitutions of the United States and of the various state constitutions. And my preposition or supposition would be that anybody who knew that this was going on at state or federal level had a duty under their oath of office to the constitutions to sing out about this right now. And I mean that you have Robin Vos, who actually was promoting the, Trump, just for, to stroke Donald Trump's ego, spending, how many millions of dollars is it now for Michael Gableman to conduct his fraud investigation. Of course, there wasn't any. It has been proven time and time again. And I think that we need to know what they knew and when they knew it, and because if you even heard something about this was going on, it was your duty as a constitutional officer to actually report it and to sing out about it and condemn it. And there's too many of them that have not condemned it.
Absolutely,
they have not condemned it, and perhaps I'm making a stretch here, but that's just, and maybe that's just one man's opinion, but. I think I'm right, because you take an oath to the Constitution.
Right.
You're elected officer. You take an oath to the Constitution, and they've all violated it.
Right.
Robin Vos and Fitzgerald and the whole bunch.
Right. No stretch at all, Mark. No stretch at all. And in fact, it also is the implicit and explicit understanding of the indictment coming out of Georgia. If you read through all of that, we're going to spend some time next broadcast going through it in greater detail. Certainly as we right now in the middle of the federal indictment alleging the 2020 election fraud issues here, you get the same sense that these are people, again, the unindicted co-conspirators, and others who are in these positions of responsibility. Let me comment on that. I think that's an incredibly important point to make, Mark, and I appreciate the call. Oath of office, absolutely. Who are the people who are surrounding the president, these people who are telling the president, as I just said, about his loss, but also, as you indicated, a larger obligation to come forward and say, you know what, I'm seeing some things here. I'm witnessing things that are indeed in violation of federal law, state law, or simply wrong, contrary to our Constitution. They had an obligation and do have a continuing obligation to come forward. We know some of them did. We see some of them in the testimony, the transcripts of the House Select Committee last year, and the report that was ultimately published. Some very bold and I wouldn't say brave. They're doing their jobs, but brave in the context of a nation in which you get threatened for coming forward and testifying about these things. Brave in that sense, coming forward and doing exactly, Mark, what you said they've got to do. You took an oath of office, whether you are an elected official, the President of the United States of America, the Vice president, we'll get to this as well, he did take an oath of office too. Turns out that Mike Pence is one of those people who did push back. And there's a major section of this indictment talking about all of the conversations that he had with the former president, pushing back on that, and perhaps not going forward and doing what you're asking him, that I would have asked him to do as well, to come forward and describe these things that he is seeing in real time, but certainly taking the stand that he is not going to go down the road that the former president is going down to try to overturn the election, saying he's got no constitutional right to do that. Obviously, in the end, we're continuing with that position on January 6th and beyond. There's another way. There's another way in which all these people took an oath of office, and in ways big and small, in ways that are charged, in ways that probably will still be charged down the road, and that is the oath of office as lawyers, too. It is significant that of those 19 co-conspirators, those 19 co-defendants in Georgia, many of them are lawyers. We're going to talk about that in greater detail next broadcast. But look at the cast of characters, even in this federal indictment. It's Rudy Giuliani, it's John Eastman, it's Sidney Powell, it's Jeffrey Clark, it's Ken Chesebro. Those 5 unindicted co-conspirators, what brings them together? Well, there is a conspiracy, yes, to undermine what should have been and was, in the end, the proper counting of electoral votes that put Joe Biden in office. But they're also lawyers. In addition to being right around the president, and they're providing political advice, strategic advice, which they can do, but they're also lawyers who are obliged to come forward in the courts and in other venues to tell the truth. Rudy Giuliani and Jeffrey Clark strike me as especially problematic. Jeffrey Clark, during the course of the Trump administration, a high-level leader of the Department of Justice, responsible for the oversight of a lot of civil litigation, environmental litigation there. Rudy Giuliani, a former U.S. attorney, also a part of the Federal Department of Justice in his past. Hugely troubling that all of these lawyers also give up on their oath, and indeed many entities around the country, including California, New York, going after them for their licenses. And we'll talk about that as well down the road. Oaths of office to the people of America, an oath of office to their jurisdictions as lawyers. When we come back, we're going to talk more about those kinds of things and other matters set forth in the indictment against Donald Trump in the federal district court. Stay with us for that final segment coming up in just a few minutes. We are back here for our final segment this morning, talking about the federal grand jury indictment against Donald Trump pending in the federal district court in Washington, D.C., and spending some time parsing through the specific allegations, anticipating some defenses by the defendant, Donald Trump, explaining how it is that those defenses will almost certainly fail, and underscoring ultimately the point that I make, which is this is a compelling prosecution. Understanding, once again, the defendant presumed innocent until proven guilty, until a jury unanimously comes back and finds him as such. But assuming that Jack Smith, as he will present all of this evidence before that trial jury, a compelling case, a hugely compelling case in this speaking indictment. That's why we're spending so much time going through it. Concern that I've had in the recent weeks about this general notion of not appreciating the nuts and bolts of the allegations themselves. It's easy when you read headlines, easy when you look at the media generally that does not have the prerogative, the time even that the civic media affords me to go through this in great detail, to think, well, gee, maybe there's not a whole lot there. There is. And that's the reason why we're spending all this time talking about the specific things in this indictment that established the defendant's, Donald Trump's, intent in doing what he did, that shut down his First Amendment claims that he was simply speaking out loud and therefore he should be exonerated, and otherwise supporting this notion that he did indeed engage in this conspiracy with others to undermine who we are in America. The indictment says specifically the defendant's knowing false statements were integral to the criminal plan that he had to defeat the federal government function. That's strong language. It's right there, returned by a grand jury to obstruct the certification and interfere with others' rights to vote. That's citizens of the United States of America, and to have their votes counted. It goes on to talk about the ways in which, in particular, those kinds of things were effectuated. Indeed, there are specific references, pages and pages, of accounts by which the defendant, Donald Trump, and these 6 unindicted co-conspirators, and probably others, reached into states like Arizona, like Georgia, which we're going to talk about again in great detail next Saturday as well, like Michigan, like Pennsylvania, and yes, indeed, Wisconsin. The accounts of the ways in which they attempt to perpetrate their scheme in terms of reaching into the states, and then also coming back to Washington, D.C., involving the Department of Justice in an attempt to overthrow the election, attempting to involve the vice president himself in doing the same thing, attempting to involve a group of false electors here in the state of Wisconsin and in other places around the country in accomplishing this multi-purpose scheme to undermine our democracy. In the last few moments, I think it's significant, given the fact that we're here in the state of Wisconsin, to talk about and recite out loud specifically the ways in which Donald Trump and these others in our state attempted to undermine the election results here. Page 20. A significant section about Wisconsin. November 29th, 2020, a recount in Wisconsin that Donald Trump's campaign had petitioned for, paid for, did not change the election result. In fact, it increased the defendants, Donald Trump's margin of defeat. And so, according to the indictment, we know this from facts as well, Wisconsin Supreme Court rejected an election challenge by the campaign, noting that nothing in this case casts any legitimate doubt that the people of Wisconsin lawfully chose Vice President Biden and Senator Harris to be the next leaders of our great country. That's in the indictment, okay? That's a finding by the grand jury. Then, on December 21, as a result of that Supreme Court decision, the Wisconsin governor, who had signed a certificate of ascertainment on November 30th, identifying Biden's electors as the state's legitimate electors, signed a significant certificate of final determination in which he, the governor, recognized that the state Supreme Court had resolved this controversy regarding the appointment of Biden's electors. And he confirmed that as the governor, that Biden had received the highest number of votes in the state and that his electors were the state's legitimate electors. That's set forth in the federal indictment coming out of events here in Wisconsin and underscoring the legitimacy of the electors properly identified to represent us, the voters at the Electoral College. Paragraph 50. That same day, in response to the court decision that had prompted the Wisconsin governor to sign that certificate of final determination, Donald Trump did this. He issued a tweet repeating his knowingly false claim of election fraud and demanding that the Wisconsin legislature overturn the election results that had led to the ascertainment of Biden's electors as the legitimate electors. On the same day, that's what the defendant, Donald Trump, does. That's what's in the indictment, the federal indictment here. December 27th, Donald Trump has a discussion. And he has a discussion with 2 people. The acting attorney general, his name we know is Jeffrey Rosen. This is after the previous attorneys general in the case Bill Barr, Jeff Sessions before him, and the deputy attorney general, the acting deputy attorney general. His name is Richard Donahue. And at that time, the defendant, Donald Trump, raised with them, those 2, Rosen and Donahue, a specific fraud claim that there have been more votes than voters in Wisconsin, okay? That's what the former president said to the attorney general and the deputy attorney general. And the acting deputy attorney general, with respect to Wisconsin, informed Donald Trump that that claim that he was making was affirmatively false, simply not true. And that, going back to the previous caller's comment, those are people inside the general government here that show, in fact, that you've got people coming forward and telling the defendant, Donald Trump, that what he believes, or what at least he says he believes, is simply not true. And again, on January 6th, the same date of the insurrection, the defendant, Donald Trump, publicly repeated knowingly false claims that there had been tens of thousands of unlawful votes in the state of Wisconsin. That's what it says in the grand jury indictment against Donald Trump. This federal indictment goes on to talk about this plan that capitalized on ideas presented by the defendants, by the unindicted co-conspirators, including co-conspirator number 5. Co-conspirator number 5, again, we've talked about already. His name is Chesbro, Kenneth Chesbro, this individual, again, charged by name in the grand jury indictment coming out of Georgia, and an unindicted co-conspirator. And he, in particular, according to the federal indictment, was an attorney who was assisting Donald Trump's campaign with legal efforts related to a recount in Wisconsin. Once again, Wisconsin looming large in this indictment. That memorandum, again, that the co-conspirator, number 5, Kenneth Chesbro, evolved over time from a legal strategy that initially was going to preserve Donald Trump's rights to a corrupt plan to subvert the federal government function by stopping Biden electors' votes from being counted, and then evolved into other ways as well of pursuing all of this. When we return next Saturday, we're going to talk more about the false electors scheme, about these memorandums, one of them called the Wisconsin Memo. We're going to talk more about Jeffrey Rosen and Richard Donahue, their engagements with the former president. I'm going to talk about false electors as well, including among our discussion, the vice president himself. And then we're going to return to the grand jury indictment in Georgia and talk in the same way with great detail about the specifics there, the premises, the predicates by which the grand jury there made the findings of probable cause that the defendant had engaged in these criminal acts. All of this a part of our continuing exposition of these charges against the defendant. Join us next week once again here on Morning Cannolis for that very important discussion. Thank you for joining me this morning as well.